The HR guidance memo stated that I should resolve concerns internally and not involve outside parties. That guidance itself violated federal whistleblower protection laws that explicitly prohibit employers from discouraging external reporting. I'd reported financial irregularities to my supervisor on February 8th. I'd documented transactions that didn't match our accounting policies. I'd identified expense reports that appeared to be fraudulent. My supervisor had escalated the concern to HR on February 10th. HR's response came on February 12th. A memo sent to me and copied to my supervisor. Subject line: Internal Resolution Process. The memo stated, "Company policy requires all employee concerns to be resolved through internal channels. Employees should not discuss company matters with external parties, including regulatory agencies, without prior written authorization from human resources." I'd worked as a financial operations specialist for a remote software company based in Denver for 2 years. I processed expense reports. I reconciled accounts. I flagged discrepancies for review. The irregularities I'd found weren't minor. They totaled over $87,000 in questionable expenses over 6 months. HR's guidance told me not to involve outside parties, but federal law specifically protected employees who reported financial fraud to regulatory agencies. The memo itself was a violation of whistleblower protection statutes. My name is Natalie. I maintained financial records and ensured compliance with accounting standards. I'd documented every irregular transaction I'd found. I'd followed proper internal reporting procedures. Now HR was telling me not to take the next step that whistleblower laws explicitly protected. I saved the memo and started researching the relevant legal protections. The Sarbanes-Oxley Act was clear. Section 806 prohibited companies from retaliating against employees who reported potential securities fraud to federal agencies. It also specifically prohibited companies from interfering with or discouraging such reports. HR's memo told me not to contact external parties without written authorization. That was textbook interference with protected whistleblower activity. I reviewed the Dodd-Frank Act provisions as well. Section 922 provided similar protections for employees who reported possible violations to the SEC. Both laws made it illegal for employers to create policies or issue guidance that discouraged employees from reporting to regulatory agencies. HR had sent me exactly that kind of guidance. I saved copies of the HR memo and my research on whistleblower protections. Then I consulted an employment attorney who specialised in whistleblower cases. The consultation was brief and direct. "The memo violates federal whistleblower protection laws," the attorney said. "Companies cannot prohibit employees from reporting to regulatory agencies. They cannot require authorization to make such reports. The guidance they sent you is itself a violation." What should I do? Document everything. If you decide to report the financial irregularities to a federal agency, you're protected. If the company retaliates against you for making that report, you have a strong legal claim. Should I report internally first? You already did. You reported to your supervisor on February 8th. He escalated to HR. They responded with illegal guidance. You've satisfied any internal reporting requirements. I thanked the attorney and returned to my documentation. I had the original financial irregularities, $87,000 in questionable expenses, receipts that didn't match stated purposes, duplicate submissions, expenses for personal items categorised as business costs. I also had my February 8th report to my supervisor, his February 10th escalation to HR, and HR's February 12th memo telling me not to involve outside parties. I organised everything chronologically and continued my normal work. I didn't immediately file a report with any regulatory agency. I just documented and violated. 3 days after the HR memo, my supervisor sent me an email. HR has requested that we close the expense irregularity review. They've determined the items in question were within policy guidelines. I reviewed the expenses again. They were not within policy guidelines. Our expense policy was explicit. Business expenses only. Original receipts required. No personal items. No duplicates. The flagged expenses violated all 3 rules. I responded to my supervisor. Can you provide the HR analysis that determined these expenses were within policy? I'd like to understand their interpretation.
He replied 2 hours later. HR's review is complete. No further analysis will be provided. Please consider the matter closed. I saved both emails and noted the dates. HR had told me not to involve outside parties. Now they were closing the internal review without providing any explanation for why $87,000 in irregular expenses were suddenly acceptable. I continued working and documenting. On February 20th, I received a performance review notification. My annual review wasn't scheduled until June. This was 4 months early. The review was scheduled with my supervisor and the HR director for February 23rd. I accepted the meeting and prepared my documentation of the year's work. Every project completed, every process improved, every deadline met. The February 23rd review was held via video conference. My supervisor opened with standard comments about my technical work, accurate, thorough, timely. Then the HR director spoke. We've noticed some concerns about your judgment in escalating matters that don't require escalation, she said. Can you provide examples?
The expense review you initiated. Those items were reviewed and found to be within policy. I haven't seen the analysis that reached that conclusion. Can you share it? The analysis is complete. The concern is that you escalated expenses that didn't warrant review. Our policy requires flagging of irregularities. I identified expenses that appeared to violate policy and reported them. That's part of my role. In the future, we'd like you to use more discretion before raising concerns. I made notes but didn't respond further. The review concluded with my overall rating, meets expectations. This was a decrease from my previous 3 reviews, which had all been exceeds expectations. I saved the review documentation and continued working. 2 weeks later, on March 8th, I was removed from several key financial processes. The email from my supervisor was brief. We're restructuring some responsibilities. You'll no longer have access to executive expense reports or vendor payment processing. Those were core functions of my role. I'd been handling them for 2 years. I documented the removal and noted the timeline. February 8th, reported irregularities. February 12th, HR memo discouraging external reporting. February 20th, early performance review. March 8th, removed from key responsibilities. The pattern was clear. This was retaliation for the internal report I'd filed. I contacted the employment attorney again. "They're building a case to terminate you," she said. "The performance review creates documentation of concerns. The removal of responsibilities suggests you're not meeting requirements. They're laying groundwork." What should I do? You have two options. Wait for them to terminate you and file a wrongful termination claim, or file a whistleblower complaint now, which will document the retaliation pattern and potentially protect your position. If I file a complaint, what happens? You file with the Department of Labour under Sarbanes-Oxley or with the SEC under Dodd-Frank, or both. The agencies investigate. If they find retaliation, the company faces penalties and you're entitled to remedies, including reinstatement and back pay. What's the timeline? Investigations take months, but filing the complaint creates a legal record of the retaliation pattern and makes it much riskier for the company to terminate you. I decided to file. I prepared the complaint over 3 days. I documented the original financial irregularities, my internal report, the HR memo prohibiting external reporting, the early performance review, the removal of responsibilities. I filed with both the Department of Labour and the SEC on March 15th. The complaints were identical: detailed timeline, supporting documentation, clear statement that I was reporting in good faith and had experienced retaliation for internal reporting. I saved copies of both filings and continued working. I didn't tell my supervisor or HR that I'd filed. I just maintained my normal schedule with my reduced responsibilities. 2 weeks later, I received acknowledgement letters from both agencies. The Department of Labour assigned an investigator, the SEC assigned a case number and requested additional documentation. I provided everything both agencies requested. On April 5th, 3 weeks after my filing, my supervisor sent a meeting invitation. The supervisor, HR director, and me. Subject line: employment discussion. I accepted the meeting and prepared for termination. The April 5th meeting was brief. The HR director spoke first. "We've been made aware that you filed complaints with federal agencies regarding your employment." I didn't confirm or deny. "We want to clarify that the company takes these matters seriously and will cooperate fully with any investigation." I nodded. "We're also suspending any planned changes to your role while the investigation is ongoing." "What planned changes?" "We were considering a reorganisation that would have affected your position. That's now on hold." The reporting ended. I documented the conversation. They'd been planning additional action against me. My federal filings had stopped it. The investigations continued for 5 months. Both agencies requested documents from the company. Both interviewed me multiple times. Both interviewed other employees. On September 12th, the Department of Labour issued preliminary findings. They'd identified evidence of retaliation. The options memo prohibiting external reporting violated whistleblower protection laws. The purporting review timing and the removal of responsibilities both suggested retaliatory intent. The SEC reached similar conclusions in their October 3rd preliminary report. Both agencies recommended settlement discussions. The company's attorneys contacted me through my attorney in late October. They options to settle both complaints.
The settlement discussions took 6 weeks. The company's opening position was standard: no admission of wrongdoing, mutual release, neutral reference. My attorney pushed for more. The HR memo had been a clear legal violation. The retaliation pattern was well documented.
Both federal agencies had found preliminary evidence supporting my claims. The final settlement included significant monetary compensation, restoration of all my previous responsibilities, removal of the February performance review from my record, agreement that the company would revise its whistleblower policies and provide training to HR staff. I also negotiated an exit package that allowed me to resign with 6 months of severance if I chose to leave within the next year. I signed the settlement in December. The payment was processed within 2 weeks. I used the 6-month resignation window. I stayed through March to complete the transition of my responsibilities properly. Then I left with the severance package. By April, I had 3 job offers. I accepted a senior financial analyst position at a larger company. Better compensation, stronger compliance culture, clear whistleblower protections in the employee handbook. I started the new role in May, 14 months after I'd first reported the financial irregularities. The work was similar: financial operations, expense review, compliance monitoring. But the environment was different. The company had robust internal controls. Expense reviews were taken seriously. When irregularities were identified, they were investigated properly. No one told me not to involve outside parties if I had concerns about fraud or compliance. A year after my settlement, I was promoted to finance manager. I oversaw a team of 5 analysts. We processed expense reports, reviewed vendor payments, and flagged irregularities for investigation. I trained my team on proper escalation procedures and whistleblower protections. I made sure they understood their legal rights if they ever identified potential fraud. 2 years after leaving my previous company, I was managing financial operations for a division with $50 million in annual expenses. We'd identified and corrected 12 instances of expense policy violations. Every one had been properly investigated and resolved. 3 years after the HR memo that had violated whistleblower protection laws, I still had copies of all the documentation: the original irregular expenses, my internal reports, the memo telling me not to involve outside parties, the federal complaints I'd filed, the settlement agreement. Those documents had shown that when HR told me not to report externally, they'd violated the exact laws designed to protect employees who reported fraud. The federal agencies had confirmed that violation. The settlement had compensated me for the retaliation that followed. Everything after that had been about building a career at companies that understood compliance wasn't just about following rules, but about protecting the people who flagged when rules were being broken. The whistleblower protections had existed before HR sent me that memo. They'd existed before I reported the financial irregularities. They'd existed specifically to prevent companies from doing what mine had tried to do. All I'd done was document what happened and use the protections that were already there.